The Honorable Court of Tennessee is now in session.
All right. Thank you, Madam Clerk. Good afternoon, everyone. This is the Tennessee Court of Criminal Appeals, day 2 of our November 2021 session here in Nashville, Tennessee. My colleagues on the 3-judge panel today from Columbia, Tennessee, Judge Robert L. Holloway Jr., and from Memphis, Tennessee, Judge Ross Dyer. My name's Robert Wiedemeyer. I'm from Nashville. We're operating under Zoom today because of the pandemic, of course. We're anxious to get back in the real courtroom, but we're also grateful that we've been able to utilize the technology provided by Nick Morgan at the AOC and our clerk's office, Jim Hibner, and of course, Ms. Kraft. We're grateful to be able to get these cases disposed of in this fashion and hope to get back to the courtroom soon. Each side, we've read the briefs, attorneys, so you know that we're prepared to that extent. We have not been assigned the records yet. Of course, eventually we'll study those records. Each side gets 20 minutes to argue. If you want some rebuttal time and you represent the appellant, you can tell me on the front end and I'll try to help you keep up with your time. And I think those are all the preliminaries. All right, thank you. And would you pronounce your name for me, Mr. Is it Anstein? How do you pronounce that?
It's Anstein, Your Honor.
Anstein, all right. Mr. Anstein, are you ready to proceed?
Yes, Your Honor.
All right, go right ahead.
May it please
Would you like me to call the case, sir?
Yes, I'm sorry. Please, Madam Clerk, call the next case.
State of Tennessee versus Steve Leslie Smith.
May it please the court. Good afternoon, Your Honors. My name is Clayton Anstein, and I'm with the Appellate Division of the Public Defenders Conference, and I represent the appellant in this case, Mr. Steve Smith. I did want to introduce Mr. Smith to the panel. He'll be stepping off as I continue my argument, but he is in the office today watching the argument. I just wanted him to introduce Mr. Smith to the panel.
All right, thank you.
Also, I did want to take a second to thank the panel for allowing me to argue here today with my limited license. And Your Honor, at this time, I would like to request 3 minutes for rebuttal.
All right. Go ahead.
There were 3 issues in the brief: a sufficiency issue, an evidentiary issue, and a jury selection issue. Mr. Smith is asking this court that if you do not vacate for the insufficiency of the evidence, that you, in the alternative, will reverse and remand for a new trial for 2 reasons. The 20+ mentions of Rolling Hills and Rolling Hills Hospital, a psychiatric and substance abuse facility in Williamson County, was not relevant to the case and was highly prejudicial to Mr. Smith. And 2, the judge's denial to strike 3 jurors for cause and a denial for defense counsel's additional time for voir dire. We will rest on the brief for the sufficiency issue unless this court has any specific questions. In this case, Mr. Smith was arrested for public intoxication in Williamson County after he was spotted by police officers walking near a wooded area while shirtless. He was followed by the police officers, taken down, and arrested near the intersection of Clovercroft and Murfreesboro Road in Williamson County after he was observed walking backwards up an embankment towards the road and not responding immediately to officers' commands. For evidence to be accepted at trial, it must be relevant to the case, it must have probative value, it must go to a material issue of the case, it must make a fact more or less probable than it would be without the evidence. Here, the consistent mentions of Rolling Hills Hospital did not fall into any of those categories. Rolling Hills Hospital, a psychiatric and substance abuse facility, was not relevant to the case, did not have any probative value, and did not prove a material issue of the case. Public intoxication is proven by the state that with 3 elements: 1, that the defendant was in fact intoxicated, that they were in a public place, and that they were a danger to themselves or others. At the start of the trial, the state tried to use the mentions of Rolling Hills Hospital to prove that Mr. Smith was in a public place when he was intoxicated. However, there is no mentions that Mr. Smith had been accused of being intoxicated at Rolling at Rolling Hills, had stepped foot on Rolling Hills or had been a patient at Rolling Hills Hospital. And clearly shown in the body footage that was presented at trial, he was not arrested at Rolling Hills Hospital. The state even conceded on page 194 of the trial transcript that there was no testimony regarding Mr. Smith's location at Rolling Hills Hospital. The state also argued that they were using Rolling Hills to give the jury context as to why the police officers were in the area. However, that argument was not made until the state's response to Mr. Smith's motion for a new trial, therefore should not have any weight as to whether it was relevant in the case or not. In any event, neither reason support a finding of relevance in this case. In denying the defense's motion for acquittal, the court said, quote, under the facts of the case, the proximity to the road clearly meets the definition of public place. On page 56 of the transcript, near the start of police officer Swain's testimony, he mentioned multiple times that the police officers were in the area because they were looking for a man who had left Rolling Hills. However, there's nothing in the record or further testimony to show that Mr. Smith had ever been at Rolling Hills Hospital, stepped foot in Rolling Hills Hospital, or been a patient of Rolling Hills Hospital. Later on in his testimony, Officer Swain says himself that they were in the area responding to a 911 call, that a man had been knocking on the front doors of a few residential houses in the area. The only reason these consistent mentions of Rolling Hills Hospital at the start of the trial was trying to plant a seed in the juror's mind that Mr. Smith had some sort of connection to Rolling Hills Hospital, which again is a psychiatric and substance abuse facility.
Was there testimony that it was a psychiatric and substance abuse hospital?
No, Your Honor. There's nothing clear in the record that it's a substance abuse facility. However, the judge was aware of it. The three attorneys present were aware of it, and the police officers were aware of it.
But was the jury aware of it?
Yeah.
There's nothing in the record that states that, but if a general assumption, if everyone, the judge, police officers, and attorneys were relevant or aware of it, that a juror could be aware of it as well.
Well, I mean, so I'm assuming that pre-trial you have some sort of police reports or this, that, and the other as part of discovery, in which these police officers mentioned in their reports that they were at Rolling Hills, or whether it's a report or whether it was investigation on behalf of defense counsel. I mean, you knew where this took place. I'm assuming you knew what the officers had said in their reports. Was there a pretrial motion to exclude any reference to Rolling Hills?
Not that I'm aware of, Your Honor.
Is there objections at trial when they referred to Rolling Hills?
Yes, Your Honor. There was, I believe, 9 objections to mentions of Rolling Hills. The first 2 were during Officer Swain's testimony when he mentioned that they were looking at Rolling Hills for a man who had left Rolling Hills. They objected to it twice for hearsay. And then later on in his testimony and Officer Gibson's testimony, there was another 7 objections by defense counsel to hearsay and leading, because the prosecutor
objected to it as hearsay. They didn't object to it as being irrelevant and prejudicial.
Well, there was a mixture of objections, Your Honor. Again, the first 2 were hearsay because of the fact that the police officer had said that they were told that a man had left Rolling Hills Hospital. Later on in the testimony and the trial transcripts, the defense does object to it multiple times for relevancy. And the court even recognized the harm that this could bring. On page 58 of the trial transcripts, during a sidebar, he mentions that he understands that the nature of Rolling Hills Hospital could be prejudicial to the jury because they may believe that the defendant has a mental problem or an alcohol issue. And this is a case of public intoxication. Any inference to the jury that the defendant has a mental or alcohol abuse problem is highly prejudicial to the defendant, especially when one of the elements is, was he a danger to himself or others? Someone with a mental problem or an alcohol issue, that presumption in the jury is going to be that he was a danger to someone if he had just left Rolling Hills Hospital and was already intoxicated walking near the side of the road. Rule 403 also said,
I would think that the jury could just as easily presume that if he was at a psychiatric drug abuse hospital, that would be the last place somebody would be intoxicated.
Right. But he
If
wasn't
we're going to
at
talk
Rolling.
about assumptions.
Correct, Your Honor. But the fact is that he was never at Rolling Hills Hospital. He had never been a patient at Rolling Hills Hospital. That is never entered into the record. There's no proof of that. The prosecution, the state was trying to make that connection in a juror's head without saying that he was, they said he left it, not that he had just graduated a program from Rolling Hills Hospital, that he was, he went through an alcohol abuse problem, that he had left the facility. And that is where the bias comes from, because you are planting a seed in a juror's mind that he had left this facility and now he is walking shirtless through the woods while intoxicated. Rule 403 says a court may exclude relevant information if the probative value is outweighed by needlessly presenting cumulative evidence. Here, the state was able to prove not only the second element of intoxication with a public place, they were also able to prove venue for jurisdictional purposes by the police officer's testimony that Mr. Smith was arrested near the intersection of Provercroft and Murfreesboro Road, which is in Livingston County, and both police officers testified to that. The state even eventually abandoned their argument of Rolling Hills, focusing specifically on the public place, and even also arguing that a church nearby should satisfy the public place element. And again, the court even agreed with that in their denial of the motion of acquittal, saying that with the facts, public place was certainly satisfied by the arrest happening on the side of a road. The state mentions Rolling Hills in their opening statement and in the first statement of their closing argument. The prosecution in their opening statement tells the jury that they will hear evidence that Mr. Smith was found in a field near Rolling Hills Hospital. However, there's nothing in the record or further transcripts to show that he was in a field near Rolling Hills Hospital. Officer Swain's own testimony places Mr. Smith in the woods near a creek that is not on Rolling Hills property. The prosecution from the very start was trying to make sure one of the first things that the jury heard and one of the last things the jury heard was connecting Mr. Smith to the substance abuse and psychiatric facility.
Did defense counsel not point out these inconsistencies in their closing argument?
In the closing argument, the defense counsel does not he mentions that he was not at Rolling Hills Hospital and that evidence was irrelevant. It was not the main argument of his closing, however, Your Honor. So even if this court finds that the mentions of Rolling Hills were relevant to the case and that they were not highly prejudicial to Mr. Smith, like I mentioned earlier, there is the question that most of the mentions of Rolling Hills were hearsay. Again, Officer Swain's testimony at the start on page 56 says twice over objections to hearsay that the court denied that he was in the area of Rolling Hills because he had been told that a man had left Rolling Hills Hospital. There's nothing, again, to show that to be true. There's no 911 calls or dispatch there to prove that. That is just Officer Swain stating twice that he was.
There's something certainly in the record to show that it's true from the standpoint of why Officer Swain, if I got his name correctly, was in the area.
The reason that Officer Swain ended up giving later on in his testimony that the state, I believe, used was that he was in the area because they had received a 911 call about a man knocking on doors in the area. There's a residential neighborhood next to Rolling Hills.
Well, that's true. Whether there was someone knocking on the door may not be true, but I assume that's what Officer Swain explained he was in the area for, why he was there, correct?
His testimony's not hearsay. You're not offering the dispatch call, so to speak, there or not. I don't understand your hearsay argument to that.
Sure, Your Honor. That his statement of that he was at Rolling Hills looking for a man, coupled with the fact that the state in their opening statement said that the jury will hear that Mr. Smith was in a field near Rolling Hills, they are offering that information as to that Mr. Smith had been at Rolling Hills, that he had left Rolling Hills. And even if the statement is not hearsay and they're just using it for, let's say, context as to why they were in the area, then that would go back to it not being relevant, because we already have a litany of reasons as to why the police officers were in the area. We have, that there was the knock on the 911 doors, and that's the argument they make later. They abandon the Rolling Hills argument. There's never another mention by the police officers that they were there specifically because a man had left Rolling Hills. Officer Swain mentions the 911 call for someone knocking on the door, and Officer Gibson responds that he was there responding to, I believe, Officer Swain's call that they had come across a man walking near the road. The 20 plus mentions of Rolling Hills Hospital were not relevant. They were highly prejudicial, and even if the court disagrees, most of them were inadmissible hearsay. Moving on to issue 2, the court wrongly denied arguments to strike for cause of 3 jurors and also denied letting defense counsel's additional time for voir dire. Defense counsel, however, did not object to this. Therefore, we do have to look at it under the plain error standard. However, the record does show a clear error in jury selection and how the trial court handled trial counsel's request for voir dire. 1 juror during jury selection called themselves a teetotaler, and 2 other juries said they believed drinking was a sin. Defense asked to strike all 3 of these jurors for cause, stating that in a public intoxication trial, Mr. Smith would not be able to have a truly impartial jury if there were jurors that had that type of feelings about alcohol. After those denials for strikes were denied by the court, defense counsel asked for additional time for voir dire of those 3 jurors. The court denied that request, not citing any rule or statute, just believing that it was not incumbent on the court to allow this. However, Rule 24 of the Tennessee Rules of Criminal Procedure do allow for additional time for voir dire, especially after a court denies 3 strikes for cause. Mr. Smith was denied an absolute right to examine jurors, coupled with the need for further examination after the initial strikes were denied, and that requires a new trial. The right to a jury trial is a fundamental right that defendants have, and that right includes a jury that is free from any biases. Unfortunately, Mr. Smith was not afforded that right, and therefore this court should grant review to correct this injustice. If there are no other questions.
I have a question. Did the defense counsel use all of its peremptory challenges?
Yes, Your Honor. The defense counsel did use all 4 of their peremptory challenges. They were able to get 2 of the jurors that they asked for cause off the off the jury, but they used 2 on 2 other jurors that they also had to strike. Again, because of the prejudicial and non-relevancy matter of Rolling Hills Hospital and the plain error that did happen during jury selection, we're asking this court to vacate the judgment or, in the alternative, reverse and remand for a new trial. Thank you, Your Honors.
All right. Thank you, Mr. Anstein. Good afternoon, General Watkins. You ready to argue?
Yes, Your Honor. If it please the court, Austin Watkins here on behalf of the state of Tennessee. Good to see y'all again. The defendant's conviction for public intoxication should be affirmed because the trial court properly admitted testimony about the defendant's location, and the defendant cannot show plain error during his jury selection. Your Honors, I think maybe the helpful thing here when looking at this this testimony from the police officers with regard to hearsay and prejudice and relevance is that it's kind of brief as one issue, but there's really 2 specific pieces of testimony that are issue, and the relevance and the hearsay analysis is different for each piece. So there were 2 officers who testified, and essentially their testimonies, and I'm summarizing, but basically was, we found him in the woods near Rolling Hills Hospital. And the reason we went there and were in the woods was because we were looking for someone who had reportedly left there. We were dispatched to that place. Okay, so there's 2 essentially different facts that are being asserted there. 1, why the officers were where they were, and then 2, where the defendant actually was as observed by the officers. So to start with, what the officers actually observed, that's not hearsay because they have personal knowledge of it. They didn't get that from someone else. It's relevant for several reasons. to prove venue, which was at least one of the primary reasons the prosecutor was asking that question, as reflected by the transcript, to establish that this occurred in Williamson County. And to be clear, Your Honors, like, he was in the woods, so he's around several different things. So the testimony is identifying landmarks to help the jury understand where this is happening, because one of the elements is him being in a public place. He's near this hospital, he's near a church, he's near this road and near this intersection, right? So he's not actually in, like, clearly in one of those places. He's kind of in all of them. So the officers are trying to help set the stage for basically putting on the body camera videos, which is essentially all the proof that this jury needed, overwhelming proof of his guilt in those body camera videos. So this was really inconsequential testimony that it was relevant to show what the venue was, to meet the public place requirement of the offense. And then also, as an important third relevance issue, is the Tennessee Supreme Court in Gilliland has pointed out that you don't have to necessarily look at the relevance of every specific fact standing on its own, as if it's assessed in a vacuum. There can be some facts that are relevant because they make other facts relevant. And that is kind of what we traditionally call context or background information. And that's what we have here. The officers, it wouldn't have made sense for them to start talking to the jury about, well, I was in the woods and I happened to cross Mr. Smith, and here's the way he appeared to me, right? That's just an incomprehensible version of telling a story. The prosecution was trying to set the stage to then move into the operative, elements, the testimony about his intoxication. And so they had to start somewhere, and they started with why they were in the woods. And so, again, to tease out the two different pieces, one, the purpose of why, like where they found him was, was to prove up those elements and show venue and to give context. This separate testimony about why they were there, responding to dispatch, it was being offered again for context to show that, we were just doing our job. And that, for hearsay purposes, is not being offered for the truth of the matter asserted, right? They're not trying to prove that someone actually did leave Rolling Hills Hospital. They're trying to prove that they are responding, to that place, right? So it's important to tease out the distinction in the two pieces of evidence, Your Honors. And then as far as prejudice goes, the defendant really says, man, I don't even remember the amount of times that he claims that the name of the hospital was referenced, but we got several problems with that. One is that there's no competent testimony or proof in the record about what connotations the jury could infer from the name Rolling Hills Hospital. From the face of it, on the plain name of it, it's kind of just a plain, nondescript name, right? A hospital doesn't really carry any prejudicial connotation. And then the trial court essentially summarizes defense counsel's assertion that the jury might infer that he was there for alcohol treatment. And then the court just says, well, I don't find any basis that, any risk or appreciable risk that is going to happen here. And so I'm excluding this, or I'm not excluding this testimony. I'm admitting it and overruling your 403 objection, right? And that gets abuse of discretion review. That's a very quintessential deferential kind of decision that the trial court gets to make under Rule 403. And so the fact that there were multiple mentions of the name, there was nothing nefarious in the record that the state, needed to prove that he had been at this hospital to somehow plant this seed in the jury's head so that they could, draw an unfair assessment of what was going on. Again, Your Honors, if you look at these body camera videos, this man was clearly intoxicated because he almost walked backwards into a busy street. Like, it was a pretty slam dunk case. The state didn't need to do anything underhanded in order to prove up what it was trying to do. And several of the mentions of Rolling Hills were kind of brought to light because of the excessive amount of objections that defense counsel made during the first officer's testimony. It's very clear that the prosecutor was trying to set the stage and move. That was what the trial court was trying to get everyone to do. But every time there was an objection, whether it was to leading, to relevance, to hearsay, to prejudice, whatever they were, and there were many, the officer would always restart his testimony, so to speak. And so that's just kind of an unfortunate compounded problem. If the defense had just let the story move on, there'd be a lot less prejudice. It really was nothing that was the center of attention that the state was trying to make, the highlight of its case, that, there's some special significance to where we found him near this hospital. That is just not any insinuation that's there in the record. They were trying to put on these body camera videos and let these officers testify about how they assessed the defendant's demeanor what they observed, what they smelled on him, and they ultimately did that. So as far as the evidentiary issues, Your Honor, there's no abuse of discretion. None of this testimony was offered for a hearsay purpose. It was relevant. And ultimately, Your Honors, if somehow this court found that there was error in this point, any error was clearly harmless in light of the overwhelming amount of guilt that there was, specifically from the body camera videos, but also from the testimony of the two officers about the signs of intoxication that they observed from Mr. Smith. And so moving to the second issues, Your Honor, about the jury selection here, we are looking at this under, plain error review. And essentially, there's only the issues confined to the one juror who was actually seated, right? So that's really all that matters. So there were two other jurors that challenged. It's irrelevant under the law. You have to show that the one juror who actually affected, your trial is somehow biased. So there's only one juror who ended up as a voting juror in this case, and her name was Miss Outland. And basically her, testimony during jury selection was, I used to, for religious reasons, because my husband was a deacon at church, I was against alcohol, but now I admit that every once in a while I have a glass of wine. And that was kind of the extent of her testimony. There were several other situations where she was questioned about, whether she could be fair and impartial, and she never said anything to the contrary that she couldn't be. And so, the defendant complains about Rule 24 not being followed, that he wasn't given an adequate amount of time to, conduct his voir dire. Well, he did get a chance to ask as many questions as he wanted. He never articulated to the trial court why he needed more questioning of that juror to prove anything. And so what we see from the Tennessee Supreme Court under Sexton, Your Honors, is that the trial court has broad discretion in conducting jury selection, the process of it. And there's nothing in Rule 24 that would be a clear and unequivocal rule of law that says you get, as much voir dire as you want. It says there's an opportunity where you may conduct further examination. That's permissive. It's not mandatory. And so under plain error review, the defendant has the burden of showing the violation of a clear and unequivocal rule of law. And he's also got to show that a substantial right was affected, and he can't show that this particular juror was actually biased. And so, Your Honors, I think that covers both of these issues here that we're talking about today. I'm happy to entertain any questions that might be helpful to the court. It looks like there aren't any, so I appreciate your time, Your Honor. The state would ask you to affirm this judgment.
Thank you, General. You still got your rebuttal time if you want to use it, Mr. Anstein.
Yes, Your Honor. Thank you. May it please the court. The state wants to bring up that the facts in a vacuum are, if they lead to other relevant issues, then they should be accepted. And if Rolling Hills Hospital has only been mentioned once or twice, then maybe we can see that. But it is mentioned over 20 times by the prosecution plus the officer's testimony. The state says that it wasn't a important part or a big part of the state's argument. However, they felt the need to mention in their opening argument in the very first sentence of their closing arguments. If it had no importance to them, then why did they feel the need to open it, start their arguments with it and end their arguments? They wanted that to be at the front of a juror's mind when they, went back to the deliberation room and looked at the case. Rolling Hills on itself, Rolling Hills, if it's said once or twice, sure, but it is said over 20 times. The presidential nature of bringing it up over and over and over again. And I know the state says that, it was only said to explain why they were in the area, but there's other testimony to prove why the police officers were in the area. There's the mention of the 911 call about knocking on doors, that he was arrested at the intersection of Clovercroft and Murfreesboro Road, that there's a church nearby. The church nearby, the intersection, those are not prejudicial on their face. The mention of Rolling Hills in a public intoxication case is prejudicial because it is trying to connect Mr. Smith, who was arrested for public intoxication, to a substance abuse and psychiatric facility. So again, we would ask this court to vacate the judgment for the insufficiency issue, or in the alternative, reverse and remand for a new trial. Thank you for your time, Your Honors.
Mr. Einstein, I have one question for you.
Yes, sir.
Would you explain, it's not really explained in the argument itself, but the third argument in the reply brief is the trial court's ignorance of the relevant statutes and procedural rules precludes a finding that the jury selection process was fairly conducted. What does the appellant mean by that?
Yes, Your Honor. That argument is going towards the the trial court not mentioning Rule 24 of the criminal rules of criminal procedure, and not, saying that it is not incumbent on the court to allow that. He did not cite Rule 24 or any statute or give any reason as to why he was denying that, other than the fact that he said it was not incumbent on the court to allow that.
Did the trial court present the statute and tell the judge to argue the statute itself?
No, Your Honor.
24? What?
No, Your Honor.
So that if there was any ignorance on the part of the trial court, it was because the defense counsel didn't present the statute to the argument. Is that correct?
Yeah, I don't know if that's specifically the only reason why they didn't know.
But you don't have anything in the entire argument after the title about the trial court. It's all about the state and their brief in reply to your original brief.
Yes, Your Honor.
All right. Thank you for the excellent arguments and the briefs, and we'll get the record and study it and render an opinion in due course. That concludes this case, and the court will be in recess pending the next case.
Court of Tennessee is now in recess.